Ms. Morrison, you may proceed when ready.
So this is basically like a prosecutor.
Good morning, and may it please the court. My name is Andrea Morrison. I represent the State Bar, along with Russell Willard and William Hermberg. We are here today because respondent harmed his clients, violated the ethical rules, and failed to take responsibility. The court asked the parties to focus on 3 issues. First,
The first one, how. The second issue, dare. Third issue, you. How dare you?
the implication of respondent's admission that the record supports a finding he violated 5.1 in all the cases. Second, the proper
Oh
application.
yeah, this is actually 6 different cases. They brought 6 cases against him for misconduct. That's why the case number is a hyphenated number there. It was 1248, 49, 50, 51, and 52.
Application of Rule 5.1, excuse me, when an attorney enters an appearance. And
If there's any kind of prosecutor that I would like, it's somebody that prosecutes lawyers, for sure.
third, respondent's level of involvement and responsibility.
It should be way easier to get disbarred, by the way. Like, Tyrone Blackburn, he needs to be done. Like, some of these lawyers aren't even trying. Like, it should be way easier to get disbarred.
For the cases as it pertains to the remaining
Hey,
rules.
Christine.
Let me address those in turn. First, respondent's admissions and the record do support a finding he violated 5.1 in all the cases. The court is therefore authorized, pursuant to the Crowther case,
Like, Moontung's case, there need to be... I could name you, like, 5 lawyers that should be disbarred because of that.
to use that in aggravation.
Hey, Christine, welcome.
And that would justify enhancing the special master's sanction. Second, by entering an appearance in all but one case, respondent fell directly under the obligations of Rule 5.1b. He acknowledged responsibility for the case and the clients, and it triggered an obligation to supervise the more junior lawyers working on those cases. And third, this wasn't just passive oversight. Respondent, either through his direct conduct or conduct he authorized, was deeply involved in these cases. Which brings me to the broader issue. Respondent wants to have it both ways. When the special master said suspension, he asked the review board to throw it out. Now he's asking this court to go back and impose suspension. But the review board was correct. And while the bar initially supported suspension, in retrospect, looking at the record, his admission, and his continued aggravating conduct, disbarment is not just justified, it's necessary.
Okay, let me explain. How much is the membership? I think it's like $4. It's whatever the default is. I didn't change it from the default. Okay, so I just want to give background on what she's saying. So there are basically 3 steps to disbarment. The first one is there's a special master, and they do like an initial review of the facts and do findings, and they make a recommendation. And in this case, the special master recommended a suspension for, I think, 6 to 12 months. The lawyer said, no, I don't want a suspension. You should throw that out at the next level up, which is the review board. And it's like a board of people that review, as the name implies, they review the special master's work. And the review board said, we agree with you. You definitely shouldn't be suspended. You should be disbarred. And that would be the find out phase. And at that point, the lawyer said, no, I should be suspended. So now he contested the suspension, and then when it got escalated to disbarment, he said, no, I want to be suspended. That's essentially what she's getting at. So him saying I should be suspended is a little hollow in this context. That's not really accepting responsibility.
I'll turn now to, more specifically, to the issues the court wanted to address.
Counsel, in doing so, could you help? I think we all recognize that we learn as we go through the process sometimes in what amounts to a prosecution sort of posture. But why was there anything specific in this case that caused the 5.1 charges to be brought in 2 and not the 4, as it were? In other words, was there anything different about the record as it stood at the point of charging that drove the decision not to charge the 5.1 in the 4 where we don't see a 5.1 charge? Or was it just totally a choice in the process?
Absolutely, there was something that made that determination. The first 3 cases that were charged were filed in January of 2022. Prior to that time, the evidence showed that respondent alone, other than some attorneys appearing in court, was the one responsible for the cases. At that point, there wasn't an indication of a systemic failure to supervise. Respondent was then deposed in those first 3 disciplinary cases. At that time, he testified regarding systemic failures to supervise and failures to have procedures in place to ensure that attorneys at the firm were complying with their ethical obligations. He called the other attorneys self-supervising. He indicated that everything could be signed under his name without him reviewing or drafting. So at that point, there was a determination of these systemic failures and these violations of Rule 5.1. However, at that time, the bar was precluded from going back and amending the complaint. The bar rules prohibit that. Specifically, Rule 4-204.1 requires that
Oh man, Aaron, I know, right?
a notice of investigation that goes to the state disciplinary board, identifies the rules.
It's like my golden retriever is self-supervising. It ate the turkey. What can I say? It's
Allegedly
self-supervising.
violated, so that a respondent has a reasonable notice of the charges against them and a reasonable opportunity to respond. In the matter of Ruffalo, the U.S.
So in other words, you could have, but you would have had to go back to the beginning. There's no amendment midstream. It's a new conferral of due process from the outset
Yes, Your Honor, and
in
the
cases
U.S.
that are already farther down the line.
Yes, and the U.S. Supreme Court stated that in the Ruffalo case, where it's
You know what's funny? I just realized this. Essentially, these questions are like, why didn't you charge him with more stuff? That's really what they're asking. They're saying you charged him with misconduct, with a specific type of misconduct, 5.1 violation, and 2 out of the 4. Why didn't you charge him in the other 4 too? It's not even like we're doubting that you proved your case. It's like, why didn't you prove more stuff? This guy sucks.
held that discipline cannot rest on charges first arising out of the lawyer's own testimony. This court has also applied that same principle most recently in the matter of Roberts' case. In that case, the court found that there were no due process issues because the rules had been pled, they had been alleged, and that lawyer had sufficient opportunity to respond. But his admissions before the court and the record before the court on those cases where 5.1 wasn't charged still matter, and here's why. In his exceptions, he acknowledges first, that the record could support a 5.1 violation, that he failed to supervise his associates, treating them as, quote, self-supervising, and that his firm's structure during that relevant time did not satisfy his professional obligations. I do want to note that these acknowledgments and admissions were only made in the face of a disbarment recommendation.
Counsel, what's your response to what seems like an argument from the other side along the lines of this is just how these practices are run? This is just how law firms of this type are run. Does the bar have a response to that?
That is insufficient to complete.
Just to preview what the other side's going to argue, they basically said that immigration law is different from other kinds of law. And so you should look at his firm differently.
Comply with one's ethical obligations. Merely having a law firm run that way does not mean that there are not ethical violations, ethical implications, and that there's not harm that comes out of these failures to have procedures in place, to have a process to ensure that junior attorneys, to ensure that other partners are complying with their own ethical obligations, to ensure that other staff is complying with their ethical obligations. He was the owner of the firm. He was the managing partner. He called himself the face of the firm. And so his acknowledgments, I will point out, are somewhat incomplete because in the briefs before the court, while saying there could be, the record could support a finding, he also disputes that there are rule violations. He says the results of these cases are as much a function of the harsh realities of immigration practice as any action or inaction on the part of the respondent or his firm. That, to me, is a belated and insincere posture, and that is something, an aggravation. So the court...
Just for more context, one of the things he argued was that his cases were hopeless anyway, and that his clients had no chance of winning, and therefore it was harmless error, basically, because like his clients were going to lose, so you shouldn't, worry about whether he violated his obligations to them. Just talking about the kind of guy we're dealing with here.
Pursuant to the Crowther case, which was a court issued last year, can, however, use that, even without without finding new violations, can use it in aggravation.
So where's the line between that and essentially using in aggravation the fact that you're defending yourself? Like our case law clearly says, like in Crowther, that we can use things like this in aggravation sometimes. But our case law also makes clear that you can't be worse off for choosing to defend yourself through the process. Where's the line between those two ideas?
There is indeed a line.
I really like Peterson too.
When a lawyer is obviously entitled to defend themselves against charges of ethical misconduct. But here we have much more than that. We have a complete lack of remorse and lack of accountability. If you take a look...
Well, but how can you defend yourself and simultaneously show remorse for things that you're saying that you didn't do? Like, how does that work?
Well, if before the court, respondent is making admissions and acknowledging that there was systemic failures in his processes, then he is attempting to show remorse. And if you look at the ABA standards in mitigation and aggravation, that is something for the court, for the special master, for the review board to consider in imposing the appropriate level of discipline.
So on that point, if a lawyer comes in and says, I did not break this rule that I've been charged with, and my evidence for why I didn't break this rule is that I broke another rule. And in fact, I didn't break what you did, I violated another rule. If they are right, they have won. In other words, if they can demonstrate I did not break this first rule, and my evidence for that is showing you how I broke a different rule, they've won, because we can't amend. They might be another disciplinary process coming or other consequences, but they've won that argument. But if they get in the posture of saying, well, I lost, I did in fact break the first rule, and even though I've now admitted to breaking the second rule, I think the question is can that second rule that they've now admitted to breaking in an attempt to demonstrate that they didn't break the first rule, if they're wrong, can it be used in aggravation in that context?
Yes, it can. And I will also note that a respondent does have the ability to file a petition for voluntary discipline at any stage, either before a formal complaint or after the formal complaint, in which they admit sufficient conduct and rule violations. That's not what we have here. We do not have a petition for voluntary discipline. If we had that and the respondent, admitted violations of a different rule and had sufficient facts and admissions of conduct, it would be appropriate then for the court to impose discipline on that rule. But that's not what we have here. Here we have essentially respondent wanting this to go away, because now we have a disbarment recommendation, and he's saying, well, maybe now the record supports a finding that I'm engaged in some misconduct, so let's go back to a suspension. That's only in the face of a disbarment recommendation, whereas throughout these proceedings and after the special master's recommendation, he has shown a lack of remorse, a lack of accountability. He's made attacks on the process. He's made attacks on the grievance. He's called the claims meritless. He has indicated that these clients...
to be fair, if you're not guilty of something, you're going to call it meritless.
He's called his clients' claims meritless and indicated that they were not going to prevail regardless.
I don't think it's an example of great behavior. I mean, the multiple motions to compel in the discovery process, this is not a cooperative effort. But what I'm trying to get to is the basis for using a separate uncharged violation in aggravation. And I'm not disputing. I'm just trying to make sure I understand the bar's posture on why it's okay to use it in aggravation, though it wasn't charged. If the defense is, I didn't do this violation because I did another violation. If it was different, where you were saying I didn't do either, right? If that was the defense, I would say, yeah, if we found that there was evidence to support it, that would be an aggravating basis. But if the defense is, I didn't do the one, and the reason I know I didn't do the one is because I did the other, I'm trying to understand why it would be aggravating as to the one that your argument failed, but you're allowed to make the argument that the one doesn't apply.
Well, what we have here is a finding by the special master and the review board that there were in fact other violations. So in addition to those violations, we have this further admission, alleged admission in aggravation. And that is why under this posture, because there already have been rule violations that have been found by the special master and affirmed by the review board, the admission, the further admission combined with the record before the court that shows violations of 5.1 could be further used in aggravation of the sanction that was initially recommended by the special master. The special master didn't conclude that there were no violations, and now we're dealing with an uncharged rule with no additional violations that were found. I do also want to go into issue 2 that the court wanted to address, and that is the proper application of Rule 5.1 when an attorney enters an appearance in the case. So we've already talked about respondent's obligations as a partner, as a face of the firm, but it's very important that in all but one of the cases, he entered an appearance both before the immigration court as well as the Board of Immigration Appeals. Now, Rule 5.1 is broken down into the 3 key responsibilities. 5.1a deals with a lawyer's obligations to ensure that there's processes and procedures across the firm. Subsection B deals with direct supervision. When a partner, a supervisor is involved in the case, they now have a responsibility to ensure that the more junior lawyers are complying with their ethical obligations and properly representing their clients. And then subsection C as a vicarious liability application. When he filed an entry of appearance in all but one case, it had 2 immediate consequences. First, it showed an attorney-client relationship. He was counsel of record in the eyes of the court. It triggered accountability before the immigration court. This has been noted in our brief, but under the EOIR Policy Manual Section 2.3, when multiple attorneys appear in a case, each is a representative of record, and each bears full responsibility for the representation.
Yep. This is
so you can't claim that he had no obligation.
This is like very basic stuff. This is stuff you learn like in your first year of law school in ethics. If you're there's no like, Mobb Deep said there's no such thing as halfway crooks. It's kind of like that, but for lawyers. You're either in or you're out. If you make an appearance, you're responsible for everything.
For these cases, he filed an entry appearance in all but one, and I want to address one argument that he's made, that he filed them for administrative purposes so that the firm could receive notices in case another lawyer left the firm. But I think that argument actually cuts against him, because by filing an appearance and appearing as counsel of record, lead attorney, it showed that he was intending to carry forward with the representation in these cases, especially since, as we all know, immigration cases.
It's kind of funny because she's like, it's really hard to argue something that's exceedingly obvious. Because what do you say? Like, the guy entered an appearance as the lead attorney in a case, and now he's like, oh, well, somebody else was on the case, therefore I'm not responsible for it. Like, how do you argue against that? Other than just... like, what do you say? What do I know about Mobb Deep? I'm just a shook one.
Can last a long time. So once he entered an appearance, the 5.1 obligations became case specific. And because it made 5.1 more concrete as it applies, his failure to do that, his failure to do anything and essentially wash his hands.
Would 5.1 B and C have applied if he hadn't made an entry of appearance?
If he hadn't, not necessarily, because at that point he still had the 5.1A obligations to ensure the processes and procedures, but because he didn't enter an appearance in each particular case, he wouldn't have had that direct supervisory responsibility.
The B and C requirements arise only from a lawyer who's actually part of the
in the case.
Right. Okay.
Yes, Your Honor. I do want.
That may also then be the case with respect to the Chevrolet, the 7634, right, where there was never any appearance of any sort entered. I mean, but the special master found that he was in fact the attorney. He
No question,
participated in the
Shamrock.
meeting.
I love.
The main, because there's never.
Honestly, like what I do, how I get these opinions or oral arguments to watch on the stream is I watch them on my own anyway, and then whichever ones I like, I share with you guys. So I would have been watching these either way. So I enjoy doing it.
Or any appearance, there may not have been a supervisory responsibility in that case.
Correct, Your Honor, and in that case, we did not charge a fine.
No, I know you didn't charge it, but I'm talking about the aggravation piece where you were going back.
Yes, yes, the record shows.
It is funny. It seems like, how can I put this? It has the tone, and like if you just listen to the tone of voice, it seems like they're disagreeing with her, or like arguing with her, or like, you know, questioning her conclusions. But that's not really what's happening. What they're really being is like, I want to fully understand all of the ways in which this guy violated his ethical obligations. They just want to, like, they already know that he did all this bad stuff. They just want to make sure they're really wrapping their heads around all of the nuances of the ways in which this guy is going to get disbarred. So they can, like, really disbar him. Because they're not really disagreeing with her. They're just trying to flesh it out. Exactly. See, if I'm trying not to curse for you know, for the algorithm, but if I could, I would, yeah, I would. Like the tone of voice is that they're disagreeing and pushing her, but they're not. No, you can say it. I don't care. I don't care if I say stuff. Would it? I don't know. We'll see. You can say curse. I don't care.
You may answer the question.
The record shows that he had involvement in all the cases.
Thank you.
All right. To be fair, I think the guy that argues for the lawyer actually did a pretty good job, but like. It's like trying to defend a toddler that has chocolate smeared on his face and being like, he didn't eat the chocolate. It's not going to go well for you.
Mr. Lee?
In the first minute or so?
Okay. Please, the court. My name is Jerome Lee, and I have the pleasure of representing
He did not have the pleasure.
and defending Mr. Taylor in these proceedings. And from the beginning, I will have, getting used to my reading glasses, but
You're not the only.
I really wanted to say he fucked around and found out when he contested the suspension only for the review board to agree with him to be like, yeah, you shouldn't get suspended. You should get disbarred. That's the funniest thing I've ever heard.
The one in that camp.
Oh my goodness, that's so funny.
but I will take questions or interruptions from the very beginning.
You love to see it.
Self-supervising mean when you're signed up as
I just love that. He says, I welcome it. Usually you get 2 minutes to not get interrupted. That's kind of more of a guideline. But it's like, you can interrupt me. Boom. Immediately questions.
Camp.
Yeah. But I will take questions or interruptions from the very beginning.
So what does self-supervising mean when you're signed up as counsel in a matter and the claim is, well, they were self-supervising? How is that in compliance with the rules of professional conduct?
Well, it fits because we are a small firm, and that group is even a smaller portion of the firm. And the individuals in that firm are all senior attorneys, and the measures and means by which they regulate each other since, I think about 2013 from the record, when the individual that was in the direct supervisor of the entire group left the firm. When the change took place, it was decided that the group would essentially govern and run itself. So the 4 senior attorneys that had done hundreds and hundreds of these cases essentially took responsibility for checking and managing each other.
Counsel, you say small firm, and I understand that from a number of attorneys' standpoint, but my understanding of looking at the record is that Mr. Taylor testified, I mean, that he had 10,000 open files, open cases at one time where he was counsel of record. That doesn't sound small to me. Is that a small number of immigration cases to be counsel of record on at any given time?
Yes, that is a bit of hyperbole from Mr. Taylor. I think the proper way to think about that.
But it is in the record.
Yes, it is there. But I don't think it is entirely accurate.
Oh God, it's a discipline hearing. It's not a good time to be like he's telling the truth, but not a good thing to be saying. Yeah, he was telling the truth about that.
Size of the firm impact the responsibilities under Rule 5.1?
It doesn't.
In other words, if I have a singular associate, I'm a practicing attorney, I bring in a singular associate, does 5.1 apply differently?
Absolutely.
How is that? What's your authority for that?
There's a case out of South Carolina, the NRA anonymous attorney.
Oh man, you're going to a different state. That's not great.
The site is NRA anonymous member, South Carolina Bar, 25346-2001. That is the best case we've seen.
25-year-old out of state
and analyzed the 5.1
case.
Requirements and how it works, how the double reasonable on each end of that requirement affects what you can expect in terms of what it means to be reasonable.
South Carolina's
Hey,
rule
Mary.
is the same as ours.
Welcome.
They're both analyzing the ABA interpretation of 5.1 and the model rule.
But in any event, you acknowledge that at least in 5 of these files, he failed to meet the 5.1 standard.
I would say that there were universal violations.
Your written filings in this court indicate that in at least 5 of these cases, he failed to meet the 5.1 standard.
Well, technically speaking, Judge, only in 2 were the actual allegations.
Didn't ask whether he was responsible for them. I'm asking, you have said, you acknowledge that though they weren't charged, he failed to meet the standard. I appreciate the State Bar's argument that one of the matters in aggravation is this continued effort not to be responsible for what you have already taken responsibility for.
Well,
Did he or did he not fail to meet the 5.1 standard in the 5 cases, not the Echeverry case where there was never an appearance entered? Did he fail to meet the standard? I didn't.
You think so he knows all 6 cases by name, by the names of the parties, and he knows the rules violations associated with each of those 6 cases off the top of his head. You think he might have looked into this? He might be a little unhappy with the attorney. I think he might have been. I like seeing lawyers get held to account like this.
I'm asking, you have said, you acknowledge that though they weren't charged, he failed to meet the standard. I appreciate the State Bar's argument that one of the matters in aggravation is this continued effort not to be responsible for what you have already taken responsibility for.
Well,
Did he or did he not fail to meet the 5.1 standard in the 5 cases, not the Echeverry case where there was never an appearance entered? Did he fail to meet the standard? I didn't say whether he can be responsible for them because I know there's only charged in 2.
I think the answer to that is yes, Judge.
Thank you.
Yeah. And so that was my point, though. But the nature of the violation depends on the size of the firm and what's reasonable for the size of the firm and what they're doing. So
Well, there isn't like some, ephemeral test for this. Isn't it just whether you are able to adequately discharge your obligations to your clients through your supervision or through your direct conduct as counsel?
That is correct. But
So can one ever do that with 10,000 appearances?
I love the way he says that is correct.
that is correct. But
So can one ever do that with 10,000 appearances?
well, that's the problem with that is the second part is that they're not actually 10,000 appearances. So
5,000?
It's not even that. So the
Are
problem.
you suggesting that a supervising lawyer in a small firm has less of an obligation under 5.1 than a supervising lawyer in a large firm? Is that what you're arguing?
I am not arguing that it's less. I'm just saying it's qualitatively different.
And
So-
how is that? How would we ever discern what is appropriate if it's different, but the standard is the same?
Well, it's because of the way that you would implement the actual measures, Judge. So when I'm at King and Spalding, there are things that I do. I report to my immediate supervisor and partner, and then if there's an issue, there's a team partner that handles things, and then beyond the team manager, there's the local manager.
Can a paralegal ever be self-supervising?
No, absolutely not.
So, but this is a really interesting position that seems to be, there's a very shifting sand throughout this. Mr. Taylor's testimony and the argument throughout has been, I'm not responsible for the 1.1, the 1.2, or the 3.2 because I wasn't counsel. In fact, I was never really actually counsel for anybody. I was only ever the face. I was only ever supervising. My only job was to bring in business and supervise attorneys. But you can't hold me responsible for supervising the attorneys. What else was he, if he wasn't actually representing the people, which is dubious, and I think the special master's findings of fact are supported, but fine, if he wasn't representing them, he was supervising them. If he wasn't supervising them, then he entered an appearance and didn't do anything. Those two things don't fit together, do they?
They do, and it's because of the nuances of immigration court. So because these cases can take a decade, if I only place a case.
It's a misconduct case, and your position is that your client just didn't do anything despite being counsel of record. That's a tough one.
In the name of the lawyer that is actually handling the case.
You can put the name on the pleading and put a generic email address that's monitored by the entire firm over the course of time.
Well, the immigration court doesn't really use email to serve.
You can substitute counsel when you have turnover at your firm.
You can, but a lot of times if someone's been there 7, 8 years, Judge, there could be hundreds of cases that could be under that person's name.
Whose responsibility is it to
excuse.
track those
Yes,
things?
exactly.
The firm's procedures and software and technology and the like process
And
track
each
those
individual attorney who is counsel of record, right?
Yes.
So when your name gets submitted to a court or adjudicatory body.
It doesn't
as
sound like
counsel
he's
of
winning.
record
It
for
does
another
not.
person, it doesn't, I mean, it's nice to have protection from your firm. It's nice to have your firm's policies, but that is your name on the record and you are responsible
Yep.
for that person until the court or adjudicatory body releases you. Yes?
That's correct.
Yeah, exactly. I completely agree with that. If it's your name's on the record, you're responsible. End of story. That's how you keep clients from falling through the cracks. That's the whole reason why you have specific attorneys assigned to cases, so you have somebody hold accountable. And in theory, if you know you're being held accountable, you won't leave your clients to, leave them to sink after you leave a firm. These judges aren't very poker faced in these hearings. They are not, especially this one. I think it's pretty clear they decided on the briefs.
So all of the 1.1, 2, 3,
Which is fine.
his name and signature are on all of those appearances. Regardless of why they are on there from the firms, I mean, what I'm trying to get at is, I think the question that was asked to the bar is, how can a firm's structural decision about how they manage their business alter an attorney's responsibilities under the Georgia Rules of Professional Conduct?
Yep.
Well, I think the most important thing to remember here, Judge, is that there are multiple entries. So it's not just Mr.
Doesn't
Taylor
matter.
placing an entry on a case.
Just because there are other people on the case doesn't mean you're not individually responsible for everything.
So in a given case, there'll be an entry from Mr. Taylor as notice attorney saying this is a Taylor Lee and Associates case. Then another attorney will be assigned to come in and be like, okay, I'm the attorney
answer
that's
the question.
actually handling all
Do
the
the
appearances.
bar rules contain a distinction between when there's multiple lawyers on a file? Does it say that only the lawyer who says they're the lead lawyer or what have you are responsible under 1.1 and 1.2 and 1.3? Or is every lawyer who's made an appearance a lawyer for those rule purposes?
And see, I think that's the problem. If the rule is the latter, Judge, then I think that you end up with a draconian result where if something goes wrong in a process and the attorney puts in an entry to do the individual, which is the merits hearing at the end of the process, then if that attorney does something wrong, then by that rule, as you've articulated, every single lawyer who's ever put in an entry is suddenly responsible for something.
If they're still on the file, I mean, what's your best case for that not being the rule?
So the best case for that not being in the rule is a case that came out of the Ninth Circuit about 2 years ago.
The Ninth
that
Circuit?
highlighted the ability of
That's
entry
California.
of appearances in immigration court.
Okay, now we're talking about presumably California, Oregon, Washington, Idaho, Utah, Arizona, New Mexico, I think. Case, maybe New Mexico? I'm not sure about that one. So it's on the other side of the country. Federal court, apparently, not even a state court. Yeah, this is not very convincing.
To serve multiple purposes. Okay. So the generic G28, E28, E27, whatever you want to call it,
Counsel, try to stick by the mic if you don't mind.
Sorry about that.
Thank you.
Do you have a cite for that case?
Did you bring any Georgia law? Probably
give me a
somewhere,
second
but
here,
none of
Judge,
things
let me
mentioned
find
so far.
That's in here.
And to be fair, I think he's doing like the best possible job that he can do. I don't think he was involved in the previous stuff. I think he's just arguing this case right now. I think he's doing as good a job as he can do, but his client's just out of luck.
It is NWIRP and Yuk Man Maji Ching versus Sessions, 2:17 CV 00716.
This is an unpublished district court order?
It is a district court order, but it was ultimately
He must have been doing some deep research
either
to find this
affirmed
one.
or they denied.
We get Dr. Robotnik's approval in the back here, which is nice.
A notice of appearance could serve more than one purpose, which very
Did I go? Yeah.
Yuk Man Maji is NWIRP and Yuk Man Maji Ching versus Sessions, 2:17 CV 00716.
This is an unpublished district court order?
It is a district court order, but it was ultimately a.
Same, bro. Same.
Either affirmed or they denied cert.
Well, I mean, even if a district court acknowledges that a notice of appearance could serve more than one purpose, which very well may be true, it doesn't change, I would assume, what the internal immigration procedures are for what that means, that you are responsible in the case, right?
It does, in the sense that.
Does it change if you enter an appearance and you're like, hey, I'm your lawyer, I gotcha, and you say that to the client?
Could you repeat that question for me, please?
So there's one set of scenarios where all you do is merely enter an appearance, and we can discuss what that means under the immigration internal rules or otherwise. There's another scenario where someone enters an appearance as counsel, but actually has contact with the client, or someone else at the firm represents to the client that person is the lawyer for the client. In that scenario, doesn't the entry of appearance obviously mean more?
No, because the converse is true. If Mr. Taylor hadn't filed an appearance in any of these cases, he'd still be responsible as a permanent partner of the firm.
Well,
So
that seems to cut against every argument you've just made.
Yes.
No. What I'm saying is he is responsible for improvising procedures that assure a certain amount of.
Responsible under 5.1.
Yes, that is the extent of his responsibility under our argument for what the entry of appearance means.
If he doesn't enter an appearance.
Pardon?
If he does not enter an appearance, but he entered an appearance in all of these cases, so that has consequences.
It has some
It
consequences.
has significant consequences under the bar rules. He's their lawyer. Once you enter an appearance for somebody, you represent them.
But at the
And
same-
why do you not take on all the responsibilities that every other lawyer in the state of Georgia takes on when you have a client that you've entered an
He just
appearance
cooked
on
right there.
behalf of?
He did enter an appearance on behalf of his client, but so did an associate enter an appearance on the
That
court.
associate has responsibilities to the client, he or she enters an appearance.
That is correct.
And
So
he's a
both are,
supervisor, right?
but he is the supervisor. That is correct. So it's the
So
same
he
way
has
with
even
any
more
of the giant
responsibilities.
firms. And, you know, with Morgan and Morgan, John Morgan does not show up at trial.
I wouldn't use Morgan and Morgan as an example. Use anybody else.
If he makes an appearance, he's still on the hook for what happens.
He is, but he is not.
It makes no difference what size firm it is. They still have an obligation. If you enter an appearance on behalf of a client, you've got obligations.
That's
Why
correct.
does an immigration lawyer get a pass from that and everybody else doesn't?
Because of the way because of the way the G28 is sort of written, and because of the way that the court actually
So looking in your brief at page 11, where you talk about this case from the Western District of Washington that you cited to us, the point I understand you to be making is the federal immigration courts have their own process that allow lawyers to do sort of limited scope representation, largely for the purpose of access to justice and trying to enhance representation for unrepresented persons. Here's the problem that I think that creates here potentially. The federal immigration courts aren't the only ones regulating the lawyers practicing before them. State Supreme Courts, through their bar rules, are also regulating those. And to the extent there's conflict between the regulations, presumptively both, the obligations from both entities still apply unless you have some supremacy clause argument that the federal dispensed with the state ones. And so it may be that there is a pattern in practice that the immigration courts have created that is inconsistent with the state bar rules. Is that kind of your position?
I think, yes, that it is. There are different rules and that there is some tension between the rules. And in a case like this, where this tension has not been addressed by any court in any of the 50 states that we could find, this is entirely a new and novel issue. And so for us, it is sort of the equivalent of, in the criminal setting, people will come in and just enter an appearance do the bond hearing. So if I lose at trial and I have to come back and file a bar complaint or a motion for new trial, I'm not going to invoke the person that did the bond. That person entered for a limited purpose, and that purpose was served, and that person's responsibility
Well,
for the
but I think there's a
That's not
different
really the
question
case
here,
here.
which is,
Yeah.
it may be that a practice has emerged that allows certain things, and it may be that
Hey,
lawyers
Shep.
can routinely take advantage of that practice so long as it doesn't violate other rules. And if there is a question about whether it violates other rules, then if a lawyer continues to avail him or herself of this other practice, they may be subject to disciplinary consequences. And that seems, maybe it's the first time someone has brought it up, but there is nothing I have heard you say and nothing I can think of that would wholesale erase the obligations under the Georgia rules for a Georgia lawyer.
And we're not saying that they do, Judge. I think the most important thing that I kind of wanted to convey and get across was that there's an adjudication of a violation of 5.1, and then there's the punishment for it. And I think that the issue is we are saying that there were superficial violations of the rule under 5.1.
You're saying, or who is saying?
I think the argument in the briefs that we're making is that there were superficial violations.
You haven't even taken care of the 1.1, the 1.2a, the 1.4, there are multiple violations. We're not only considering the ones that you've admitted, right?
I would argue that without the 5.1, the others are attempting to impute to another
But
lawyer
counsel,
behavior
the
that he
special
did not do.
master found as a matter of fact that Mr. Taylor represented those people in the direct capacity,
He's heated, and I get it.
not in a supervisory capacity. And you have to acknowledge that the record supports that it's not clearly erroneous because his signature is on their filings in court saying, I am this person's attorney.
Well, I think that's actually part of the issue and the reason why we did concede on the 5.1.
So bear with me for just a minute. what you're saying now sounds like, well, there's this way we don't understand, but you haven't litigated it that way. You initially sort of didn't participate. You slow played the participation. You didn't get your evidence in. You said, no, there's nothing to see here. And now all of a sudden you're saying there is something to see here, but it's just very different. It's a unicorn. But those things all took forever to come out. Why?
Why? That's a good question. I like that.
Well, I think the larger problem here is it wasn't that there was a delay in getting it out, is that the proper questions were never asked. And so in a lot of these cases, while there is an analog from immigration cases to criminal cases, the analogy is not perfect. So for example, one of the big things in immigration court is when you come in, you have to concede removability or not from the very beginning, which is a quasi-equivalent of saying, I'm guilty. So you walk into the court saying, I am guilty. So these proceedings are very, very different than others. And so not only do you admit to guilt, what you then say is, but I have this minor exception that I think I apply for, and I'd like the chance to present that.
And we understand that difference. Before your time expires, can I ask you about one argument that you're making on aggravating factors?
Okay.
And that is prejudice to the clients.
This is a tough part.
One argument that you're making on the prejudice point, at least as I understand it, was that these cases were all losers anyway. And so whatever happened from the lawyer's side could not have prejudiced them. Is that your argument?
Essentially.
If they were dead bang losers,
You should be disbarred just for making that argument. And then readmitted and then disbarred again.
from the start, recognizing that the effect misconduct has on outcome is what our precedent says we look to for prejudice, does that potentially open a problem on accepting the case to begin with? I mean, if you take a client's money with no prospect for helping them, unless you have papered the record really clearly to say we advised them that there was no possible help we could offer and we took their money anyway because they
To
insisted.
turn up the volume.
Is that fraudulent? I mean, is there a failure to inform the potential client that they're paying money for nothing?
The answer to that question is no, Judge. And it goes to that these processes are oftentimes more elaborate. So even if I'm defending you in immigration court, normally the purpose of defending is to buy time to find an actual basis for adjustment. And if you go through our engagement agreements, all that's sort of laid out, and the things that we say we can do and what we don't do.
So recognizing that buying time is something of actual value, to the extent the claim here is that these clients...
I didn't hear that, Danny, but I'm incredibly unsurprised. Ooh, I want to listen. I want to go back and hear it now. I hope you guys don't mind.
Inform the potential client that they're paying money for nothing?
The answer to that question is no, Judge. And it goes to that these processes are oftentimes more elaborate. So even if I'm defending you in immigration court, normally the purpose of defending is to buy time to find an actual basis for adjustment. And if you go through our engagement agreements, all that's sort of laid out, and the things that we say we can do and what we don't do.
So recognizing that buying time is something of actual value, to the extent the claim here is that these clients were effectively abandoned, can't that affect how much time you could have bought them?
Well, that's the point. We're arguing they were not abandoned.
Okay. All right. Thank you, counsel. Ms. Morrison, I believe you have 4 minutes remaining.
Yes, Your Honor. So I agree that immigration proceedings may be different, but the application of the bar rules to immigration lawyers is not. We're talking here about a lawyer's responsibility to the clients. There was a lot of discussion about what effect the entry of appearance had in the case. What we have here, in all but one of the cases where there was no entry of appearance, is much more than that. What we have here is filings, letters, submissions to the court. And as far as the harm, Chief, you asked about if these cases, it was just buying time. Well, in a lot of these cases, the clients lost the opportunity to present their full case. There was a failure to submit documents within a 15-day period of the hearing.
If we only looked to the type of harm that your opposing counsel has articulated, which is there was never really a chance in the first place, wouldn't that effectively insulate this type of lawyer from ever suffering bar discipline on the theory that there was no harm to the client?
It absolutely would, because in imposing a disciplinary sanction, you're looking at the duties, you're looking at the mental state, and you're looking at the harm. And the harm in these particular cases, there was significant harm. I will submit
What was the harm? Because my read of our precedent is that typically in the harm space, when we're talking about effect on the representation, as opposed to stealing money from trust accounts or things like that, is that we tend to look at the difference in outcome. What's your best case for we look for something other than difference in outcome?
We have to look at what the clients, if they lost their ability to pursue a claim. So I would point the court to cases in which a lawyer didn't file a case within the statute of limitations.
Well, the record also has ancillary costs, right? I mean, there's record evidence that at least one of them, I think, paid $10,000 to another attorney to try and fix what they.
Yes, Your Honor.
He knows
many
his
of these
record
clients
stone cold.
retained
I
other
love it.
lawyers in an effort to reopen their cases. There was one client where the appeal was never filed, and it was an asylum case. The appeal was never filed during the time, although the client was told the appeal was filed. The client hired another lawyer, paid thousands of dollars, and has since then had their motion reopened, and their asylum claim is still pending. There's another client in which the documents that were to be submitted within that 15-day window were never submitted, and so they were not considered by the court. And so these clients lost the ability to present their full case.
So one of the points that Mr. Lee made that I think is central to their defense at this point in the case is that this really is a novel intersection between the state rules of professional responsibility and the way federal immigration courts operate. Are you aware of another case addressing something like this? Certainly not from our court, but anywhere in the country. How novel is this really?
I am not aware of another case. I will end with the fact that I also think we have to look at this case. It is distinct from maybe other cases involving immigration practice, because here we have a high level of involvement and also a high level of failure to be involved at the same time. Everything was in his name. He wanted everything to be in his name. In the eyes of the court, in the eyes of the client, he was their lawyer. And in the eyes of the court and in the eyes of the client, he failed to adequately represent these clients and violated the rules, which justifies the recommendation of disbarment.
Thank you, counsel.
Thank you.
Thank you,
Damn.
counsel, to both sides.
That closing line was, if I was Cat Williams, I'd have like a fire like highlight right here. But I want to listen to that closing again. That was fantastic.
I am not aware
Fire overlay. That's what I was trying to say.
of another case. I will
This part.
end with the fact that I also think we have to look at this case. It is distinct from maybe other cases involving immigration practice, because here we have a high level of involvement and also a high level of failure to be involved at the same time. Everything was in his name. He wanted everything to be in his name. In the eyes of the court, in the eyes of the client, he was their lawyer. And in the eyes of the court and in the eyes of the client, he failed to adequately represent these clients and violated the rules, which justifies the recommendation of disbarment.
Thank you, counsel.
Thank you.
Thank you, counsel, to both sides. We will get you a decision within the time that it requires us to get it done. So, thank you very much. We're going to.
He said that funny. Yeah, he did get that done. Let me show you. Where are you? This one? No. This one? No. This one? Yes. So this was about less than 3 months later. You'll see here there are actually six disciplinary cases against him. This is a 56-page opinion. Just to skip to the bottom line, literally all of them agreed that he should be disbarred. Right before Christmas, just to rub a little salt in the wound. These six matters, I'm not going to read the whole thing, I'm just going to read the first paragraph. These six matters are before the court on the report and recommendation of the State Disciplinary Review Board, which reviewed Special Master Lavonda Rochelle DeWitt's report and recommendation. In each of these six matters, Christopher Casey Taylor, that's a very nice bar number, a member of the bar since 2002, is charged with violating several provisions of the Georgia Rules of Professional Conduct regarding clients of the law firm where he is a partner. Taylor's law practice and that of his firm has a heavy focus on immigration matters. Indeed, all six of these disciplinary matters arise out of representation in the context of immigration law. The special master recommended a 6 to 12-month suspension with a condition on reinstatement, while the review board instead recommended disbarment based largely on its conclusion that Taylor's lack of remorse should weigh heavily against him. Taylor initially denied that he was culpable for any misconduct regarding the grievance cases, but he now concedes the record supports a determination that he violated the rules concerning supervision of other attorneys, and he asks this court to impose a suspension consistent with the special master's recommendation of discipline. However, with the benefit of oral argument and having carefully reviewed the record, we conclude that disbarment is warranted. If there's interest, maybe I'll come back and read this whole thing, but I don't think I have 56 pages of reading me right now. Can you try to get into another state to practice? If he hasn't already been admitted to another state, it's unlikely he's going to get in. When you apply to practice in another state, they check your bar record. Do a full background check usually. And this would come up, and I would assume this would preclude him from ever getting admitted in another state, unless he does a whole bunch of stuff like retaking a full bar exam, doing ethics stuff, probably waiting a few years. It would take a lot of effort to get admitted in another state. Georgia also doesn't take the universal bar exam. Yeah, I know, Aaron. Thanks for reminding me. Oh, God. I gotta show you guys something. I can't even get him to take a divorce case for low cost. I mean, he'll probably take it. It probably won't be low cost. And you'll probably end up being married to a second person by the end of his representation. You'll be double married. Look at these questions. Not these ones. I'd have to learn how to do this stuff again. After about 4 years ago, friends Celia and Victor decided to open a bookstore together in Savannah. Celia contributed $60,000 in cash, but she lives in Seattle and has never been involved in running the business. Victor operates the store and makes all the management decisions. For the first year, Victor performed these duties without taking a salary, and he and Celia agreed his sweat equity during that year would constitute his capital investment. After the first year, Victor began to receive a salary of $40,000 per year. Other than Victor's salary and the rent payments described below, no amounts have been paid or distributed to either Celia or Victor. I don't care about Celia or Victor. Celia or Victor? Celia or Victor? I want to do criminal stuff. I don't want to learn about Celia and Victor and capital contributions again. I knew this stuff once. I don't want to do this again. Just let me be a lawyer, Georgia. Please. What kind of business entity has been created by Celia and Victor? A limited partnership, a limited liability company, a general partnership, a corporation, or something else? It's clearly a general partnership. How likely is it that Victor has the right to unilaterally dissolve the business relationship with Celia? If he does have the right to dissolve, what does he need to do to effectuate the dissolution? You can always study on stream so you can grift at the same time. That'd be funny, actually. On January 10th, 2023, Perry Smith went to see his podiatrist, Dr. Botchett, and that's kind of funny, for treatment of a painful ingrown baby toenail. I don't want to learn about ingrown baby toenails or regular baby toenails. I don't care if Perry Smith has a painful toenail. I got people in prison I got to get out. I don't want to learn about toenails. Dr. B is a resident of Fulton County. The medical services at issue occurred in Fulton County. Perry is in DeKalb County. Oh, it's going to be a venue question, isn't it? Where will you file a complaint? Exactly. Counties of Georgia. Name all 159 counties. All right, question number 3. Alice and Bob met in 2000. That's a family law question? I have to learn family law again? I only studied family law on the way to the bar exam in California. That's the only time I spent learning family law. And I actually learned like the one topic I needed to know. Right after the ball, guy said pattern and practice consistent with... Oh, really? I'm going to have to go back and listen to that. Identify all the streets with peach in the name. Peachtree Lane, Peachtree Street, Peach Lane Tree, Peach Street Lane, Peachtree, Peach Tree Street. Oh, then this is, see, I'm not worried about this. This is the I don't know what they call it, the practice thingy, the competency exam, I guess. They like want you to show that you're actually a lawyer and know how to do stuff. They give you a bunch of stuff and tell you to write something like a lawyer would. I feel like I should just be able to like show them something that I've actually written in the real world, and then like the opinion that says I was right, and then that should be enough to get me in. Like I don't have like hypothetical stuff. I have like real stuff I've written. Just let me in. Just kick out certain people that I'm not going to name and give me their license. Oh my goodness. Just send them a link to my channel. That's what I'm not going to do. I'm going to have to private my channel right around the time they're looking into me. I've said some things that some powerful people might disagree with. Okay. I got to call it a day because I got to do some work. I think I'm going to record a video later today, another Moontoon video. That's funny. Lawnerd Amber just retweeted me. He said, y'all, come join and listen to this fucking pathetic excuse for why an immigration attorney figures his performance did not warrant being disbarred. So it'll piss you off. Spoiler, he was disbarred. That's true. You can rename to Supreme Court of Georgia Fan Club. I am a fan of their 8 out of these 9 attorneys. I'm not going to tell you which one I don't like, although I've explicitly said it more than once in the past. Ooh, I'll show you next up. Let's see. You can't see what I have these called. Winchester Sicko Mode? No. Mr. Ashley Merchant, looking right here. We're going to get back to this one soon, I think. The second best lawyer from Maine right there. But, okay. Those are some of our most vulnerable community members. Oh, definitely. Definitely. They're definitely most vulnerable. And also, like, if they lose the case, they're, presumably they're going to get deported. And it's not like they can, their recourse is just practically limited because they're in a different country. So, like, you can get away with so much, I would assume. Look, he is what he is. What do you want me to say? Oh, man. So, yeah, I'm going to do a Mooktunk video. I think I'm going to start breaking these streams into videos themselves. So, like, I'll break this into 3 videos for each of the 1 oral arguments. So people can go back and watch those individually if they want to. I should have been doing that this whole time. But I'm lazy. I'm fundamentally a lazy person. Like, I'm actually a very, very deeply lazy person. I'm just also very petty. And that makes me work hard sometimes, unfortunately. Okay. I think I'm going to call it a day. I'm going to do that. And, yeah. Hey, Kat, are you streaming tomorrow? I assume Kat's streaming tomorrow, because I think... Wait, tomorrow's the... No. Tomorrow's Sunday. Monday's the start of the thing, right? You're streaming tomorrow, too? Okay. Yeah, I'll still live stream. I'll just put them on, like, not live, too. Tomorrow's... Okay. Yeah, it seems like Kat and, what's his face? The guy with the cool name of the podcast, Trial and Error, I think. They've really been driving a lot of attention to this case. And also, you know the best thing about the Holly Bobo case? What really, like, warms my heart is how mad it makes Nancy Grace. She's so mad. And there's not like, if I had to choose between myself being happy or Nancy Grace being unhappy, I would rather both of us be unhappy than myself be happy. Love and grace. What can you say? If we get a prosecutor named like Mercy, we gotta watch out. Yeah, Kat and I watched, I don't know if anyone else was there, but it was on Discord. We watched an episode of Nancy Grace talking about the Holly Bobo case. It was fun. She was so mad. Delightful. All right. Okay, I'm going to go offline now. I'll see you guys. I'll probably come to cast stream tomorrow. I'll post a video later, or maybe early tomorrow. We'll see. But yeah, thanks for watching. I'll be back soon, I hope. I never know how to say goodbye, so I'm just gonna head out now.